Now, just everyone. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. It's Tuesday, January 25th. We have 6 bills on our voting list. The first bill, Senate Bill 84, Senator Young, has been withdrawn, so there's a motion for an unfavorable withdrawn. Is everyone okay with that? All right, excellent. All right, second bill is Senate Bill 172. We'll turn over to council. Go ahead.
This departmental bill repeals obsolete references, including to the J. DeWeese Carter Center, and provisions that authorize DJS to establish and operate facilities.
Just a name change. All right, motions for a favorable. It's been seconded. Is everyone okay? Excellent. All right. Well, now it was unanimous. Passes favorably. We'll now move on to Senate Bill 176. Josh, go ahead.
This departmental bill requires that a person transporting a child under the age of 2 in a motor vehicle secure the child in a rear-facing child safety seat that complies with applicable federal regulations until the child reaches the weight or height limit specified by the manufacturer. The existing law provides that a child under the age of 8 simply has to be secured in a child safety seat. The existing penalties are $50. It's not considered a moving violation. And it's not contributory negligence and may not be admitted in evidence in a civil action. So there is an amendment in your packet that's number 413625/1. I think this amendment needs kind of a slight additional amendment to it. The idea was that it would make a first-time violation where a child under the age of 2 is secured in a child safety seat that's forward-facing rather than rear-facing. It would provide that a first-time violation like that would be a warning. So if you look on your amendment, it would simply require that the current amendment language is a person who violates subsection D2 of this section, and then we would simply have to insert additional language by securing a child under the age of 2 in a child safety seat that is not rear-facing is subject to a written warning for a first violation. So that would be the amendment.
Just real quick, before I go to Senator Huff real quick, do you want to adopt this amendment first, or you want to provide your inquiry? Okay, can we move to adopt the amendment first? Is everyone okay with that? All right, first, excellent. The amendment's adopted. We're going to Senator Huff.
Yeah, so I'm struggling to figure out what this bill does, because it says, if you look at the current law, it says that basically you have to put a child in a safety seat who's under 8, quote, in accordance with child safety and vehicle manufacturer instructions. So you have to follow the instructions of the child safety seat and the vehicle manufacturer. So if these seats are manufactured to be rear-facing now, which this is all different, I don't know if anyone here has done the rear-facing. My kids are a little bit older now, where we only did the rear-facing when they were infants is the way they did it, but I guess this has all changed. But it seems to me they would already be required under the current law, because the child safety seat would say on there it's supposed to be rear-facing. And so that seems to be a problem, is when you get into this of specifying explicitly what the seat requirements are, well, these things change constantly too. I mean, it's changed since I've had kids already. Basically the law says you got to put the kid in the seat the way that's required. And then just lastly on that, I mean, the only way a police officer can enforce this, because if you look at what they're saying here, is it says, reaches the weight or height limit specified by the manufacturer of the child seat. So the only way a police officer could figure this out would be to actually have the specifications of the seat. But that's kind of what currently the law says anyways, that you got to do it by the specifications what the seat requires. So I don't actually think this does anything.
Yeah, I don't, off the top of my head, know whether the applicable regulations and guidelines specify the forward or front facing. I think the way the bill is drafted contemplates that they deal with height and weight limits. So I would have to look and see whether they tend to specify front or rear facing. But because the requirement in the bill would be specific, it would override any, if the manufacturer specifications were, rear facing until 3 years, the bill would have more specific provisions on that point.
It seems to me that the simplest thing is the current law, where you just follow the manufacturer's recommendation, so that we're not in here every year trying to change it based on that. And what if our law contradicts what the manufacturer says is safe or prudent?
I mean, to the extent that involves whether it's rear or front facing, because we have a specific requirement in the bill, that would always override if, if the.
Yeah, and I just think these things change too. I mean, they do. I mean, it's just like the guidance changed on cribs, where if you, put the baby on the tummy, on the back, that's gone back and forth. Or even this rear facing, front facing has changed. So I think the current law is totally fine. It says do it by the manufacturer's guidance.
I thought the language is more elastic than that. So I thought it said, so it's secure the child in a rear-facing safety seat that complies with the federal regs. Break until the child reaches the weight or height limit specified by the manufacturer, which could change and is elastic too. So both of those things can change. It allows for flexibility in both sides, the manufacturer and the regs.
D1 already covers D2. I mean, D2 does it in different language, but D1 says you got to put any kid under 8, you got to put them in the seat in accordance with manufacturer's instructions. And the manufacturer's instructions are for a kid of certain ages and weights, turn it around. And so this is actually redundant, because actually this is already the laws. And when you really look at it, right, we're covering the same thing.
I mean, this doesn't, I guess we're giving this more debate, but if you look at the list, everything else on here is going to take 2 seconds, so. But we're trying to show our new senator here how we debate these things. I mean, I would concede, I think the only thing you could add to the current law is say end federal regulations. I mean, that would be the only thing that would be an addition that would, I think, be of any importance. But I don't know. I just struggle to. It seems to me the current law is pretty good. Put the kid in the seat. How the seat and the vehicle manufacturers say it, and no matter how that changes, our law is not stuck with that, because this rear facing thing. I mean, my youngest is 8, so in the last 6 years no one was doing that 5 or 6 years ago, and unless they were infants when they were very little, you did the rear facing. But then you flipped them around. So this is in the last 4 or 5 years. And 4 or 5 years from now, they could have a different change. So I think it's better just to make it follow the manufacturers of the seats. And that's what the police officer got to use anyways. If we would add anything to the law, we could say end federal regulations.
So I'm about as long away from these as Senator Huff, and I expressed this poorly before, but my recollection is not that the manufacturer's instructions indicate that they should be rear-facing until a certain weight or height and then turn. My recollection is simply that it includes that second part. In other words, not that it should be rear-facing, but that it can be rear-facing or front-facing, but at a certain weight or height, it must be front-facing. So the manufacturer recommendation doesn't necessarily mean that it should be rear-facing before that time. My recollection is that the manufacturer leaves it up to the consumer, and that's why this bill is necessary. That the bill is saying until the manufacturer recommends the turnaround, it should be rear-facing, regardless of whether the manufacturer is providing you with that option beforehand. So that's my recollection.
What was what is the thinking on the rear, on keeping them rear-facing anyways? I mean, because you'll go forward.
I'm just out of this now, as daughter just turned 3.5. But so it's the manufacturer's guidance was keep it backwards, like rear facing until a certain weight and height, so that the neck and the so that the neck muscles could mature enough to withstand an impact if you're front facing.
I'm just thinking, what if you're hit from the other side though?
That's what the guidance was.
There's nobody odds. Most accidents are from the front. They're just playing the odds
I don't know. I mean, I'm thinking back to when we did it. I kind of worried about not being able to see my child because a lot of times they're in the back eating Cheerios or whatever, and you can't actually see them. They're like facing the other way.
You're a bad parent. You're not supposed to give them Cheerios in the car. Everybody knows this.
You ever done a
Just
long
'cause
road? You
you're
ever
gonna
done a
find
long road
Cheerios
trip
for
with
the
kids?
You're gonna find Cheerios for the next 3 years. That's the only problem with that.
You clearly have not been with kids in a car on a long trip in a long time.
Just
Rob.
because I'm saying it doesn't mean I do it. This is the Senate.
This man had 3 grandchildren in like 3 months, you know?
I'm just glad we're
I got-
out of this
I
with
got
the
car
rear facing
seats.
because the whole trick was the minivan with the DVD player right there. You know, that saved us. But now that's gone. This bill wipes
Baby
that
car
out.
seats.
So look, let's do this. We'll hold this until Friday. Great debate. Or we can kill it now, whatever you want to do. We'll jump ball if you want to do that. But it's, if you, we can get some information on the federal regs. I thought we had that, but let's get with the federal regs and see if it's necessary. This will take 2 seconds when we come back on Friday. Of course, this would happen. But I know this is,
Are we holding it with the amendment adopted?
yeah, amendment adopted, so yeah. All right. All right, we're gonna go on to Senate Bill 198. Go ahead, Josh.
This departmental bill authorizes the Secretary of Public Safety and Correctional Services on a case-by-case basis to award a death benefit if additional evidence arises on or after January 1, 2006, that the decedent's death resulted from an act performed against the decedent by another due to the nature and performance of the decedent's duties. The application for a benefit would have to be submitted within 3 years of the finding of evidence to support the claim, rather than the general rule that it would have to be submitted within 3 years of the death. It would apply retroactively, and that is the subject of the amendment in your packet, which is number 643824/1, which makes a technical change to the retroactivity clause at the end of the bill by removing the reference to January 1, 2006, because the case that inspired the bill, the death actually occurred in 2001, so that is to make sure that the bill actually applies to that death. It also makes some technical changes. It removes a reference to the department in that clause, because a lot of the people who are eligible for death benefits are not employees of the department. And it also just corrects the language a little bit to make sure that it really does apply to any potential case in the past.
Question. Then it would cover Mr. Collins' case, right?
Correct, with the amendment.
Even with the amendment?
With the
okay.
amendment, it would.
Okay, move on. Yeah, move on. Let's move it on.
So there's been a motion for a favorable, it's been seconded, is everyone okay?
Do the amendment.
Oh, sorry, to adopt the amendment, is everyone okay adopting the amendment? All right, excellent. So now the bill's before you as amended, is there a motion? All right, seconded, everyone okay? All right, awesome. Favorable with amendment,
Unanimous.
unanimous. All right, now move on to Senate Bill 214.
Senate Bill 214, this is another departmental bill. This bill expands the circumstances under which a report of child abuse or neglect may be disclosed to certain school personnel or director of a licensed child care facility or licensed child placement agency. The bill also authorizes disclosure to a CPA following a report of suspected child abuse or neglect alleged to have been committed by a household member, family member, or person who has responsibility for supervision of a child in a home that is approved by the agency. The best way to understand the second point that I just went over, this appears on page 2, lines 27 through 31, is with the following hypothetical. So under current law, a CPA recruits a woman to become a foster mom. She goes through background training, certification. She would be considered an employee of the CPA, and if DHS received a report of child abuse, the CPA could be notified of the report of child abuse against the foster mom. However, if foster mom has someone who is a live-in boyfriend, a sister, or somebody else who has responsibility for supervision of the child in the home, a report or disclosure of child abuse or neglect against that person could not be disclosed to the CPA. That's what this bill is trying to address with that point.
So that anyone who's in that house, in that location, in that facility, now you have access to their background with respect to child abuse, if there's a complaint filed of child abuse.
The bill would authorize at
disclosure.
DHS's, they would have the ability to make the disclosure to a person who has responsibility for supervision of a child in a home that is approved by the agency.
Does everyone understand the bill? Questions, thoughts, concerns? Senator Watson?
Thank you. So if I have the responsibility for taking care of a child and I have some other folks in my household and I step away and go to the grocery store and they're watching this child and something happens, what I thought I heard you say is that the agency has no jurisdiction over those individuals, only me. Is that what I heard you say?
You can go ahead and say it.
Yeah, so under that circumstance, it would be if DHS would get a notification for like an anonymous tip-off saying that a regular babysitter at this foster parent's house had previously been accused of child abuse. Mm-hmm. Under this bill, CPA or DHS could then notify CPA of that report. Currently, they wouldn't be able to because that person's not considered an employee.
The CPA branches out to different placements, like different houses or locations. Let's say house A has 3 people living in it. One person that's working for the CPA, right now, is the only place where you could disclose that information if they have a record of child abuse against that person. But if they have a boyfriend or someone else living there that has an allegation or a complaint of child abuse against them, then that information cannot be shared with the CPA.
I understand.
Okay.
Thank you.
Sounds good, like a good bill. It's like a no-brainer.
So everyone okay? Is there a
Favorable.
motion for favorable? It's been seconded. Bill passes unanimously. Then there's another question, though, just a follow-up, is that, I think we talked about this, but why would, if there's a facility or a location that has a complaint of child abuse, why are they still on the list of eligible places where a CPA could place a child? I would like to know that, because it's kind of, that seems like you should be like on the do not call list or something. I don't know. I don't know.
Maybe it's just an allegation,
Yeah, maybe, I don't know.
That could probably be a separate, so this is just doing.
No, I know that. I know that.
Oh,
This is a separate line of inquiry because of
Gotcha.
what we, separate bill, something, idea, but it would be just interesting to know that. Okay, excellent. We'll go into our last bill of the day, Senate Bill 218.
This departmental bill authorizes the MVA to issue a temporary renewal for a driver's license or identification card for up to 2 years for certain applicants. The authorization does not apply to a commercial driver's license. You would still have to have all the documents required by federal law and a photograph on file that won't be 16 years or older by the date of the temporary renewal. And I would just note that the way the bill is drafted, essentially it identifies specific groups of people who would be eligible for the renewal. Essentially, it's active duty armed forces, members of the Foreign Service, and various residents who are temporarily outside of the state. But then it would also authorize the MVA to do it for any other resident who meets any requirements that are developed by the MVA.
Do you trust? Sorry. The only thing is I'm not trying to tank the bill or anything, but the only thing to think about is the last piece that he mentioned, right? It's just, I don't know. What are your thoughts?
I like it.
if it makes the MVA work better, I'm for it.
Gives them more discretion, that's for sure.
I think it just makes it so that less people have to go in there too, and right, it makes it a little better.
Yeah,
Favorable.
less people, less often. Is there a motion for a favorable? It's been seconded. Hold on before we roll it. See Senator Castley's.
No, I was And any other resident of the state who meets the requirements approved by the administration, I just.
Yeah, that's what
There's
I was-
always that little catch-all, which basically renders the entire rest of the bill. It could have been a one-line bill that says.
Anybody, right?
Yeah, it's anybody, but we're gonna list all these, but that's okay. Hey, I don't wanna mess with, just with the legislative drafting process, so I'm fine.
All right. All right, motions for failed and seconded. Is everyone okay? Excellent. Unanimous. Senate Bill 218 passes unanimously. All right, that's it. That's the last bill we've got. I'll see you all. All right, let's see. Do you want to assign floor leaders? When do these go to the floor? Probably Wednesday? Thursday?
Distribution on
Friday?
Tuesday,
Yeah.
and then second reader on Wednesday, because Monday is a pro forma session.
Oh, so this is next
Most
week. That's right, because
likely,
this is
right.
Tuesday. Right now. Yeah.
Oh, wait, no, this is Tuesday. I
This
was
is
thinking
Tuesday,
it's
so
Friday.
Thursday,
Just
Thursday.
kidding.
Thursday. So Thursday.
Yeah, let me confirm that with the president's office.
Okay, who wants, we'll quickly assign these real quick. Senate Bill 172, since it's Carter Center, let's do Senator Carter. All right. Who wants Senate Bill 198? It's actually pretty, all right, Senator Sidnor's got that. Senate Bill 214. I'll take that, it's fine. And then Senate Bill 218. Senator West, awesome.
Wait a minute, we didn't give any to Senator, the brand new senator. Put him out there already? I don't like none of them.
Let's give him a field, he'll get one on Friday, he'll get a good one on Friday. Yeah, really? All right, that's it, all right, thank you.